Hello, everyone. Welcome to the AIA Contract Documents webinar on important legal considerations for home builders. Everyone who's attending today is going to receive a recording of the presentation that we'll go through today, as well as the slides. So keep an eye out for an email from AIA Contract Documents with those slides and recording after the presentation. Just a quick disclaimer to get us started that none of the content we go over today should be acted upon as legal advice. We'll be going over some standard form contracts. If you have any kind of issue that you think requires legal attention, we encourage you just to reach out to a local attorney. Another quick disclaimer that the presentation is protected by copyright laws, and that just pertains to reproduction, distribution, and display, because again, you will be receiving those slides. So as a quick kind of poll to get us started before I hand it over to our content experts and our main presenters, is I just want to again take a quick poll. If you're in the audience and using that raise your hand option in GoToWebinar, can you go ahead and raise your hand as an attendee if you are a home builder yourself? All right, so it looks like we have a lot of home builders. So then if you wouldn't mind, your home builders can put their hands down and use that raise your hand function if you are considering hiring a home builder, if you are building a home or a homeowner. All right, some of those as well. And then finally, you guys can put your hands down. For those of you who are design professionals, do we have any design professionals? We have some of those as well. All right, so it looks like we have a good mix here. Hopefully everyone will find something helpful in the content. So with that, I'm going to go ahead and hand it over to our presenters for the day who are going to take you through the presentation. So I'll pass it over to Susan and Marika to introduce themselves and take you through the real content.
Hello, everyone, and good morning. I'm Susan Van Bell. I am an attorney, and I am currently working as a consultant, been doing that for about 1.5 years. Prior to that, I was Senior Director and Counsel in the AIA Contract Documents program for 12 years. And before that, I was in private practice with a construction law firm.
Hi, I'm Marika Snyder, and I'm an architect. My day job is teaching at the University of Memphis, and historic preservation is kind of my area. And then I also have a side hustle, which is an architectural firm that's been around for 18 years, and we do design build work. We occasionally design for other builders, but we never build anything that we don't design in-house. And then I'm a serial old house buyer, so I kind of come at this from the side of both of design professionals, from building, and then also from homeowners.
So today we're going to talk about legal issues for home builders, and we're going to do that in the context of how your contract addresses those issues. I assume most of you are using written agreements for your projects. Let's talk briefly about the importance of a current contract. A contract is essential for risk management because it allocates risk to the proper party, partly through insurance and partly through the contract provisions that address the scope and responsibilities of the parties. Contract law is a changing area, and it's important to use a current contract to keep up both with law and practice. In residential construction in particular, it's important to use to know the requirements of your jurisdiction, as residential construction is viewed in something of a consumer protection framework. And so a lot of jurisdictions have their own requirements for things like disclosures that the home builder has to provide to the client. We'll be talking about that a little bit more further on in the program. The contract is also a way to educate the client about the construction process, which is another important area in residential. Many residential clients have never been involved in a construction project, and so it's important to walk your client through the contract so they will understand what to expect and what they are required to do. All of that using a contract that properly allocates risk and using the contract to educate the client can help avoid disputes during the course of the project, which is really what the goal is. Next slide, please. So we're going to be talking about legal issues today, but we're going to do that in the context of these two new homebuilder agreements that the AIA has just published. We're going to be talking about how these issues are addressed in these documents because we thought them through a lot, and we feel like we addressed them well and thoroughly. So there are two documents we've just published, the A111 and the A112. They're both agreements between owner and home builder. A111 is for construction only of a single family home, and then the A112 is for design and construction of a single family home. And Marika and I were both on the group that developed these documents. So we know of what we speak here today when we talk about some of the discussion about some of these issues. The AIA already publishes design bid build residential and design build residential agreements that are popular, and these two are based on those prior documents, but these are the first ones where the parties are the owner and the home builder. So as with all the other AIA agreements, we developed these documents to delineate the roles and responsibilities of each party and to provide the kinds of contractual protections that are important to allocate risks in this kind of project. These documents contain provisions that may never come into play in your projects, but they're there to protect you or the owner, or both, if the relevant situation arises. And as I mentioned, A111 is construction only, and A112 is both design and construction. Next slide, please. So what's unique to residential construction? We have here jurisdictional requirements, consumer protections, and client relationship. And we're going to go into all of these in more detail as we go through the program. This is setting the framework for the kinds of issues that are really unique to residential. And I'm going to start with the client relationship, which is unique in residential because, let's face it, the client is emotionally invested in their home. The client is probably not knowledgeable about the construction process or the terminology used, so you probably often hear, what's an allowance? The home builder may have a lot of explaining to do and managing of expectations and has to work hard to keep that relationship going smoothly. I'm sure all of you home builders out there have had clients with unrealistic expectations. Some of this is because of a lack of understanding about the construction process, and we will address some issues related to that. Having a clear and comprehensive contract not only helps to educate the client, but it can help to diffuse some of the emotion if things get bumpy and everyone knows what they agreed to. If you're having a dispute, you can point to something in the contract that addresses what the issue is. People have to kind of calm down and realize that they're going to have to comply with what the contract says. As I mentioned before, jurisdictional requirements vary from place to place with respect to residential construction. Some of this is tied into the next item, the consumer protections. These issues can govern everything from the kinds of notices or disclosures you have to give to a client, specific language that may need to be used, the type of dispute resolution you can go into, and other issues. So these are things you have to be very aware of. Next slide, please. So let's start with the key information that a good residential construction agreement should include. Next slide. Okay, so here we have the kind of the major items that we're going to talk about, items of key information that are essential to include in the construction contract. And we'll go into them in detail in this presentation. So you can see relevant parties and contract documents, statutory and other requirements, contract time, contract sum, payment, insurance, dispute resolution, and termination. And after we talk about these things, we'll talk about the scope and the responsibilities of each party, and then some other issues to consider in an agreement. As I mentioned earlier, we're going to be addressing the issues we discussed in this program by talking about the way we handled them in the A111 and A112 home builder documents. We're not going to talk about the design process that's in the A112 today, because we're going to be talking about the issues that are common to both documents. And I can mention now, if you're interested in these documents, you can go onto the AIA Contract Documents website. You can see samples of them. And so if you wanted to see that design component of A112, you could take a look at that. Next slide, please.
So the first thing is talking about who the relevant parties are. And so these are who is the decision maker, who's the spokesperson. And this is particularly important if there's a couple, whether both people have to sign off or it's one, or it could be either one. And also who's responsible for payment. If you have consultants, it's great to list them here, such as an interior designer or a landscape architect, to put that into the contract if you already know that. If you don't know, you can say to be determined later. And then separate contractors would be, for example, if the owner is going to hire like a pool builder separate, that's not part of this contract, it really needs to be named in the contract so that that can help the home builder coordinate. And then the key personnel, this is more so on the contractor side. Who is the person to reach out to for if there's problems, for payments, and also like the foreman that's going to be on the site. List those personnel, because when someone has a problem, they can just go back to the contract and all of that information is in one place. You don't have to look for 100 different sticky notes. The second part of this is the documents that actually make up the contract documents. So it's not just the agreement or the contract. It includes the agreement as well as the drawings and specifications, because these are the things that define the scope and quality of work to be done, and that's part of the contract. And then any written change orders that happen after the agreement is made become part of the contract documents. And if there are any other documents that are legally required to be adhered to, these need to be specified as part of the contract documents so that everyone understands what they're agreeing to. Next slide. So Susan mentioned previously about statutory and other requirements. We did a brief survey and discovered that there is a huge variety of different requirements specific to home building, which is different from like commercial construction. And much of this is to protect consumers. And so some jurisdictions require specific protection notices to be given to homeowners. There might be certain warranty requirements based on the jurisdiction. And even like mechanics liens, that's different how you file them from state to state, and sometimes different in different counties. So there's also other jurisdiction requirements that might happen based on where the property is, such as a sustainability requirement or a wetlands overlay or historic preservation or even zoning. And so it's important that all of these things are listed so that the contractor can know what requirements they're required to adhere to. And also if there's anything like a homeowners association. Like for example, and this is just one, in Connecticut, you actually have to attach a notice of cancellation to your contract, and it has to be written in 10-point font minimum and be bolded. So it's important to know what the requirements are for your area so that you can comply with that. Next slide. The contract time has a fill point for the commencement of construction. That's pretty straightforward. But substantial completion is actually a concept that not everyone understands, and you can use the contract to help the client or the homeowner understand how the process works. Because when you say done, what does it mean that you're done with the project? Well, the term substantial completion means when the work is sufficiently complete that the owner can occupy it. This doesn't mean that every little plate is on and every little nick has been fixed, right? That's what we have the punch list for. But there are a lot of things that trigger at substantial completion, so when it can be used for its proper purpose. And so this is a great way to educate homeowners about that process. Next slide. The contract sum is intended to be a stipulated sum, but there are fill points that allow you to put in other provisions for determining the cost of the work. If you're doing a cost plus contract, you would need to do significant edits to this contract, and I would suggest there might be other agreements that are more suitable and that are more specific to cost plus, because there are a lot of details about, for example, what is part of the work and what is part of overhead. So you may also fill in your allowances, or you might attach a list of them if you have a form that you use all the time. So traditional examples of allowances are things like appliances or plumbing fixtures or lighting fixtures, because those selections haven't been made when you're signing the contract, but you're going to need something for it. You need a budget number, but you want some flexibility in case the homeowner selects very expensive fixtures or appliances. Lately, I'm actually seeing lumber packages have been included in contracts as an allowance, as a way to manage for the price escalation that we're seeing. And then other assumptions that should be made part of the agreement need to be listed, and then you could fill in like clarifications or exclusions. For example, clarify that the price does not include the pool, but it does include the pool deck. We're going to have a lot of pool examples because it's nice and hot, and I've been having pool on my mind. Next slide. The payment process is based on a schedule that's determined by the parties. Typically, you would have amounts to be paid at construction milestones, such as when you finish the foundation, when the building is dried in, etc. If there is a construction lender, it's very important to make sure that the schedule and the systems and the payment plan work with any schedule that's established by a lender. Sometimes there's a requirement that they have to review things, and so make sure that you understand the lender's process so that you can put that into the schedule. Next slide.
So now we're going to talk about insurance, which is an essential item because it is a key area that helps to manage risk. Whoever is in a better position to insure a risk is the entity that should have that insurance and have that risk covered. So these documents that we're talking about require pretty standard coverages, and there are fill points for, the minimum amounts of the coverages. And let me also mention, most of the things we've talked about so far, in fact, I think all of them, there are fill points in the documents. This is information to be discussed between the parties and provided. So, for example, when Marika was talking about those statutory requirements, there's a series of fill points for, the warranties and various items, and that is designed to prompt that inquiry and discussion to make sure that the home builder knows what things are required, and in other areas, the payment process, what are the milestones going to be? What are the amounts going to be at each milestone? So these are items where the parties have to discuss this information and fill it into the contract. So again, the insurance is pretty standard. The home builders coverages are the commercial general liability, automobile liability, workers' comp, and employer's liability. Those are at statutory limits. Builder's risk, and then there's a fill point for other in case the project requires some kind of specialty insurance. And the owner's coverages are the standard property and liability insurance. One thing to watch for is that in some jurisdictions, contractors are required to post their insurance coverages and licensing information with the governing agency, and it might be available on the agency's website so that the clients can look it up. Next slide, please. Dispute resolution. Now, I don't know how many of you have this addressed in the contracts that you're using, and nobody really wants to think about dispute resolution when they're going into a project. But it's a good idea to think about it in advance and decide how to handle it if that situation should arise. So the AIA documents contain a section with checkboxes to select a dispute resolution method, and you can select arbitration, litigation, or you can fill in some other type of method, maybe some kind of review board or other things that might be utilized. The choice between arbitration and litigation really kind of needs to be weighed. For a period of time, arbitration was greatly favored in the construction industry. Now there seems to be a little more of a balance between arbitration and litigation. One advantage of arbitration is that if you can get an arbitrator who is knowledgeable about construction, that would help. If you file a lawsuit and you could have a judge and a jury who don't really know very much about construction, and of course it's a process and a lot of it is kind of nuanced, and so it's nice to have someone who knows about it already. A note of caution here is that in some jurisdictions, again, that consumer protection framework that they look at for residential construction, arbitration may not always be favored. Sometimes there's a feeling that, because you have a right to file a lawsuit in court, that if someone agrees to go to arbitration rather than going to court, they may have given up that right without quite understanding what they're doing. And so that's one thing to watch out for wherever you're located. And then, of course, the choice might depend on the cost and the complexity of the project itself. You might have a claim that could go into small claims court. Most of the other AIA documents require mediation before going to arbitration or litigation. We did not include that as a separate requirement in these home builder agreements because typically before arbitration or a trial, the parties will end up engaging in mediation anyway. If you're going to arbitration and it's governed by these AAA rules that you see on the slide, those require mediation first. If you file a civil suit in court, most of the time, if it's a substantial claim, the court is going to order mediation. And so, depending on how that plays out, it may not cost as much as doing a private mediation. And so we thought we would not require mediation in these documents. And again, if you have a claim that's small enough to go to small claims court, it wouldn't make sense at all to pay for a mediation. So the rules that we cite here, the AAA, which is the American Arbitration Association, Home Construction Arbitration Rules, and then the AAA Construction Industry Arbitration Rules. The home construction rules have limits. So if they go up to $1 million in a claim, but if you have more than $1 million claimed, or if you have to join other parties, it's a more complex type of situation, then you would have to use the arbitration rules. Next slide, please. Termination. Here's another one. Nobody wants to think about it or talk about it, going into a project. Obviously, you hope your project will go smoothly, it'll work out great, the client will be happy at the end, and end of story. But unfortunately, terminations do happen, and it really is one of those things that it's very helpful if your contract talks about how termination will be handled, particularly in terms of how you settle, the compensation. So we have 3 different termination scenarios. The first one is termination of the owner by the home builder for non-payment. And as you can see, the process is once the owner is 30 days past due on the payment, the home builder can give 7 days notice to the owner that the contract will be terminated. And then if that happens, the home builder is compensated for the work executed and for costs incurred due to the termination. Now, the second one, owner may terminate for convenience. That's where the owner can terminate without really having a reason, and that's something everybody wants to avoid. And obviously, it may be where the owner just decides they found another contractor who will do it for less money, or the relationship goes bad and they just don't want to work with the home builder anymore. These are things we really don't want to encourage to have happen. And it does kind of go back to the nature of residential work, where the owner and the home builder relationship is very close, and the owner is very emotionally invested in the project. But it's rarely in anyone's interest for the owner to terminate for convenience. And so even though the contract allows it, we have tried to discourage it by including a provision for a negotiated termination fee, which requires the owner to pay the home builder that amount if there's a termination for convenience. So, this may cause an owner to think twice about doing it, and at least the home builder will receive something to help make up for the loss of the rest of the job. And then, of course, the owner can terminate for cause, and there's a specific list of reasons that we have provided in the 2 agreements we're talking about. One is when the home builder refuses to or fails to supply enough properly skilled workers or proper materials, fail to make payment to their contractors or subs, disregard the laws or the rules of the jurisdictional authority, or is otherwise guilty of substantial breach of a provision of the contract documents. And if there's a termination for cause, the owner is entitled to finish the work, and then the balance due to the home builder will be determined by how much is left of the contract sum and whether or not it costs the owner more or less to finish the work. And really, unfortunately, this does come up a lot when we talk about, at the end of the program, I'll show you some resources the AIA has that can help you when you're using our documents, or if you want to use the documents. And one is a service called docinfo, where you can call or you can send an email and have a question about a document. And although the staff attorneys are not allowed to give legal advice, they can answer questions, especially for things that are contained within the agreement. And so, there were docinfo questions where someone got into a situation and there was going to be a termination, and they wanted to know, does their contract help them with that? And oftentimes it was just a matter of, saying, I can't talk to you about the facts of the situation, but if you look at the termination provisions of your agreement, if they were using an AIA agreement, we could point them right to the termination provisions, and often that was helpful. I mean, you're going to sign the contract and put it away somewhere in a file and probably not pull it out and look at it too much, except maybe the deadlines for the payments, until you have a problem. and then you may not remember what was in that contract that addresses that. And so, you know, when people would call us and we would just have to tell them, oh, that's in your document, look at section 9 or whatever, they'd be very happy to hear that. So, you know, as I mentioned earlier, you may have a lot of provisions in a contract that will never come into play, but if you need them, it's really good to have them there. Next slide, please.
I'm just going to say one other thing on that past slide. The termination for convenience, it could also be things that aren't flippant choices by the homeowner, but it could be like, let's say something went wrong with financing and they didn't have the money to complete the project. That's not the contractor's fault, and so that would fall under termination for convenience. Or heaven forbid, the couple got a divorce, or there was a hurricane that came through and they decided they weren't going to rebuild on that. I guess that wouldn't really apply a hurricane. But anyway, some other thing that happens and that it's not at any fault of the contractor. All those would fall into termination for convenience. Okay, thanks. Next slide. So now we're going to talk about clarifying the project itself and the scope of the project, and then also the responsibilities of each party. Next slide. So the home builder will perform the work in compliance with the applicable laws, statutes, ordinances, codes, all of that. This is why it's so important that in the previous section, you list all of the different regulations and things that are going to affect the construction process, and that the contractor is required to abide by. That way, it's clear what the rules of the game are, because the contractor is stating that they will actually follow all of these things. And then the home builder will also supervise and direct the work using their best skill and attention. Next slide. Now this one is a great one for educating the home owner. The contractor is solely responsible for and has control over construction means, methods, techniques, sequences, and procedures, and also safety, and for coordinating all portions of the work. So this is clarifying to the homeowner that the builder is responsible for the safety, what happens, and the owner doesn't dictate those things unless they are part of the contract documents. Another important thing is permits and fees. These contracts are stated so that the permits and fees are obtained by the home builder, because the home builder is going to have a relationship with municipalities and better understand how to submit for permits. And then the builder will give the permits, the licensing, and inspection approvals to the homeowners. This is really important because depending on where you are, permit fees can be really expensive. And so the home builder needs to make sure that there's an allowance for that within the budget. I worked on a project in, it was an infill lot in a suburb, and there was a $15,000 tap fee just to plug into the existing water line. And that was, well, we learned our lesson after that one. That was a big surprise for us. So make sure that you have an allowance for all of these things. Next slide. The home builder also warrants that the materials, equipment furnished in the contract will be new and of good quality unless otherwise required or permitted by contract documents, which is great. This is something that you would normally expect. I've actually had exceptions to this because in preservation work, occasionally we might want to have materials that are not new. For example, when restoring a brick house, I'll oftentimes specify salvaged brick to be used. But if we want anything other than new, that needs to be designated in the drawings, the specifications, or in the agreement, because otherwise the home builder is warranting that all of the materials are good, are new. And then also the home builder warrants that the work will be free from defects, not inherent to the quality required or permitted. The contractor does not have to build to absolute perfection, but to the quality required. And that's that the work will also conform to the requirements of the contract documents. Okay, next slide.
So now we're going to turn to the scope and responsibilities of the owner. So one is financing, and this is before commencement of the work. If the home builder asks the owner to provide evidence that they have made financial arrangements to fulfill the owner's obligations, the owner has to provide reasonable evidence that they have done that, and also that any contingencies for funding have been satisfied. That would be typically if they have a lender and there are some contingencies. The home builder does not have to commence the work until the owner provides that evidence. And then if commencement of the work is delayed while waiting for the owner to provide that information, the contract time will be extended appropriately. We also added a section requiring the home builder to provide a schedule for the owner's selections, so that the owner will have to make selections in a timely manner and not hold up the project. This includes product and material selections to be made by the owner, as well as items for which the home builder will provide samples. The provision we included in our documents says that the owner's approval will not be unreasonably delayed or withheld, but the schedule has to allow the owner reasonable time to review and consider selections. But again, we think this is to the advantage of both parties, really, to comply with this, because it just moves the project along in a timely manner. Next slide, please. Now, this is important. In the home builder agreements, there are a number of items of information that the owner must provide. So you can see the list here. Property or site covenants, conditions or restrictions, homeowners associations requirements, special characteristics or requirements, surveys. These are essential pieces of information that the home builder will rely on. So it is important for the home builder to be sure to go through this with the owner and obtain the information. That way, the home builder is protected if something goes wrong based on information that the owner should have provided and didn't provide. So, homeowners association requirements, there may be limits on the color of the house. So, if you paint a purple house and they come back, the owner says afterwards, oh, I forgot, we can't have a purple house. Well, then that's on them to have to pay for that correction. And again, because these documents are specifically for residential construction, we did include items that are unique to that, such as the homeowner association requirements. And then the last bullet, the services of geotech and other consultants, if requested by the home builder and reasonably required. I mean, not all residential projects are going to need those kinds of consultants, and so we didn't make any of them mandatory. They are if requested. Next slide, please. More consideration. So now we're going to talk about a few other issues that are important to address in the construction contract. There are other provisions in these AIA home builder agreements that we don't have time to go into in this program. Things like hazardous materials, access to the site, and other important items. We just don't have time in an hour to cover everything, but as I mentioned, you can obtain samples of these documents on the AIA website and take a look at those items. Next slide, please. Starting with owner's rejection of work, which is a big one. And as I mentioned before, Marika and I worked on these home builder agreements and were part of these discussions. And this topic had a lot of discussion. So what the documents say is that the owner may reject work that does not conform to the contract documents And if the contract documents reference a standard for performance or quality of the work, failure to meet the standard is considered non-performing. That second point is what really came out of our discussions. You know, owner's rejection of work is a difficult topic in this kind of a project. Undoubtedly, many of the home builders out there have had experiences where a client has had unreasonable expectations. And again, as Marika mentioned before, we're not trying to say that the owners are always flippant in these situations, but you know, an owner may not really understand how to interpret the contract documents. You know, what does it mean for something to conform to the contract documents? And so we had a lot of discussion about how to try to place some understandable limits around the owner's right to reject work. And we added what's in the second bullet point about referencing a standard, and that's to try to provide some guidance that the home builder can point to and the owner can understand if the owner is questioning whether some of the work was done properly. And I think Marika has some examples of that kind of situation.
Yeah, one of the great guides is the NHB publishes the Residential Construction Performance Guides. So as like an example, the interior wall finish section says, quote, any nail, pop, blister, or other blemish that are readily visible from a standing position facing the surface of a distance 6 feet under normal lighting conditions are considered excessive, end quote, right? That's great. It's very clear, because it says basically that, you know, 6 feet away, if you're seeing nail pops and other blemishes in the drywall, yeah, that needs to be fixed. That's clear. But if you get up and you're like 4 inches away with a magnifying glass and you've got a light right on that and you're like, look, I can see it here, that's not really realistic. And so a lot of these published standards can help guide this conversation, because it can go either way. There are home builders who don't always perform to a high quality, which is not most of them, but we want to be able to have the homeowner reject those things, but also not reject things that are too particular. I also like to use the Architectural Woodwork Institute quality standards. That has a great guide for for anything to do with wood. And I've had projects where the client freaked out because the tile in the bathroom was a 32nd of an inch off, and it was just just barely imperfect, and that was really within the standards. And then on another project, the mortar joints varied from 1/2 inch to 1 1/4 inches, and that was absolutely not of an acceptable quality and had to be redone. And so this is a good way to allow for predictability and also good quality but reasonable expectations for the work. Next slide. So changes in the work is always something that gets contentious, that can get contentious as a project goes on. But changes happen in most projects. So the homeowner and the builder may agree on changes to the work, and then with a contract sum and a contract time adjusted in writing, and this becomes a change order. If they cannot agree on the contract sum, the home builder gets paid the actual cost of the work plus overhead and profit. And then if the contract sum and the contract sum and the time are equitably adjusted if concealed or unknown conditions are found. For example, I had a project where we had actually done soils testing, but then when we got to the foundation, we discovered some very unsuitable soils in one area that hadn't been sampled with the soils test, and it required a massive amount of concrete to be pumped in there as the solution. And because of a provision like this, we went back to the owner and said, this was an unknown thing, and the owner agreed to compensate us for the extra amount that it cost. In this case, it didn't actually take extra time because we just had like 18 hours of concrete. But if something is discovered, especially with the soils or any other kind of thing that might require the time, it might take 3 more weeks because something has to be dug out, or there was a cistern or something hazardous under the ground, then the contract time should be changed to compensate for that. Next slide. All right, substantial completion, one of my favorite topics. We talked about that briefly before, but the home builder, at substantial completion, the home builder will submit a list of items to be completed, the punch list. And then the owner makes an inspection to confirm that list. And then the home builder will prepare a certificate of substantial completion for the owner's approval. And like we said previously, substantial completion is defined as the work being sufficiently complete to be used so that the owner can occupy it. And there's a lot of the certificate of substantial completion can trigger warranty and lien periods. So it's essential to have that listed and also to recognize that that's different from absolutely completed, moved all the tools off the job site and asking for a final payment. Now, at that point, and at substantial completion, that's when the owner generally takes over responsibilities for insurance and utilities. And then when the final payment is due, the owner will inspect the work and then will make final payment if the work is acceptable. And the home builder has submitted the lien releases and the other documentation. Next slide. Now, the home builder is also responsible to promptly correct any work that was done not in accordance with the contract documents, and the home builder bears the cost of correction of the rejected work. And as Susan mentioned previously, however, if the work had to be corrected, for example, the purple house in the beige homeowners association, that was not something that the contractor had done improperly. That would be borne by the homeowner. So the correction of the work is things that were not in compliance with the contract documents. All right, next slide. And then liens. Again, this is important that the builder is familiar with the jurisdictional requirements. And lien releases often require very specific languages, so it's essential to make sure that the documents comply with this so that the liens can be either effective and then also effectively rescinded. And this is why the AIA doesn't actually publish a standard form for lien release, because the requirements for specific language or notarization, et cetera, differ from one jurisdiction to the other. Next slide, please.
Okay, so this is just a reminder that all of the terms in the contract do form binding obligations. So the home builder needs to know the terms and follow the terms with care. And you need to educate your client and walk through the contract with them to make sure they understand it. A contract is binding. Failure to comply with it is a breach of the contract. So both parties need to understand the agreement and do what they are required to do as it says and as it applies to them. This is how a contract can help avoid disputes if it is comprehensive and can help take some of the emotion out of a situation. When you can point to a contract provision that addresses a problem, there isn't much to argue about if the responsible party has complied with that requirement. And as I mentioned earlier, you might have quite a few provisions in a contract that never come into play, but if an unexpected situation arises and you can point to a provision in the contract that addresses it, you're in a much better position. And as far as the client education, again, it's just going back to, in this situation, you're going to mostly have clients that really have never been through a construction project before. And so the contract is a great way to educate them on how it's going to go and manage the expectations. And it's important, really important to make sure the client understands whatever the contract binds them to, and as well what it binds the home builder to. So why should you use an AIA contract document? You had to have known there was going to be a sales pitch here, but you know, we have been talking about the two new AIA home builder agreements in the context of the issues we've been discussing. Some of you may be familiar with AIA contract documents, but if you're not, we just want to talk about why you should use them for a minute. Of course, you know, from everything we've covered already, you can see we've already done a lot of work in developing these documents and considering these issues, and so you already have that. But there's also a long history of the AIA contract documents program going back over 100 years. And the documents are updated periodically to reflect changes in both practice and the law, which is very important. And going back to the very beginning of this program, I think the first slide was why use a current contract. You may be using a contract that you developed, you know, years ago, and client signs the same thing every time, and it may not have kept up with what's going on now in terms of practice or legal issues. And so it's important to have a current contract, and AIA keeps their contracts current in that way. There's a lot of interpretive case law on the AIA documents. You know, Marika talked about substantial completion. The AIA's definition of substantial completion is widely accepted throughout the industry. There are a lot of other terms used in AIA documents that have been basically adopted by the construction industry. And, you know, courts have interpreted the AIA documents in many cases. And so there's a lot of legal precedent to rely on. And now the AIA publishes almost 200 agreements and forms, which, again, a lot of that reflects changes in the construction industry. I mean, there are a lot of delivery methods now. So, you know, it used to pretty much be design, bid, build, and then design, build, and construction management, and integrated project delivery. And we're happy to say we are finally have something out there just directed towards the home builders. Next slide, please. So the objectives when AIA contract documents are written is to, you know, they're called the industry standard. Again, that goes back to a lot of what was on the last slide. But the fact that they've been around so long is a testament to the balanced nature of the documents. Any standard form contract heavily weighted to favor one party would fall out of order fall out of use in short order. And so the AIA documents are written to try to balance the scope and the responsibilities and the risks between the parties, as well as balance the competing interests and put the risk where it is best managed. And so you may have heard that some people say that AIA contract documents are unfairly tilted towards architects. The two home builder documents that we're talking about today, though, actually don't include the architect as a party. And the process that the AIA uses is designed to bring in the interests of other shareholders in the documents. So, for example, when we develop these home builder documents, we reached out to home builders to review the drafts of the documents and to provide comment. And their comments were taken very seriously in terms of making revisions to those drafts. Next slide, please. So I just want to mention also the documents we've been talking about today are for residential home construction, but if you do other types of work, if you do any commercial or other things, the AIA has many other owner-contractor agreements, also project management forms. Those include payment applications, change orders, certificate of substantial completion, a lot of items that, might be useful to you, even doing residential. So how can you get the documents? 3 ways. You can, and you see the screenshot of the purchase page from the AIA website. The basic single document is a locked PDF with fill points that you fill out, but you can't edit the text. Then the custom single document is a PDF you can fill out the fill points. I'm sorry, it's not a PDF. It's an open document. It's a Word document, and you can edit the text for the document. So if you think you need to make changes to the standard text, as well as filling in the fill points, the custom single allows you to do that. And then the unlimited annual subscription allows you access to the AIA's entire document library. You can use the templates as many times as you want, and you can use whatever templates you want over the period of time for your subscription. Next slide, please. Resources and contact information. The AIA has a lot of material to help you select documents, use documents, and also just information about the construction industry and the construction project. You can look at the ACD Learn and ACD Help web pages. There's a YouTube channel where you can see videos about various issues involved in construction. And then there's docinfo, which I mentioned earlier, which is where you can call or send an email and get an answer to questions about the documents. A lot of the questions have to do with, do you have a document for whatever, or sometimes a specific question about what a document says. And the AI is very good about providing answers to those questions. And then for problems with using the document templates, you would contact the tech support folks, who are also wonderful at helping people using the templates. And also, if you're interested in the 2 new home builder agreements, A111 and A112, there are FAQs on the website, and you can look at the samples. There's also going to be another webinar on July 8th on how to fill in the fill points in those documents. So that will be a very, practical-oriented webinar where the presenters, one of them will be Marika, will walk you through the document and explain, how to fill it out. That's on July 8th. And then I'll also mention we're expanding this residential document suite. We'll be publishing 2 new agreements for custom residential projects, an owner-architect and an owner-architect and an owner-contractor agreement. Those will be out in August. And we are working on developing a remodeling agreement as well. The A111 and A112 could be used for remodeling, but they are more than really what you would need in a remodeling project. And so, we're developing something that's somewhat scaled down and addresses some specific issues to remodeling. So thank you for attending today. It looks like we might have about a minute to answer some questions. If you have a question that we can't get to today, please send it to the docinfo service and we'll make sure you get an answer. Thank you.
All right, thank you, Susan, and thank you, Marika, for bringing your expertise in these documents and all of those real-life examples. I also appreciated the pool examples, Marika, so thank you for that. Let's go ahead and answer just one question in the audience to take us to the end of the hour. One person from the audience is wondering, generally, what should be the expectation on the maximum length of a time a home builder can place in the contract? Is that years? Specifically, the allotment of time to complete the project.
Well, I would expect that it matters how complex the project is. It could range from a few months to a couple years, or for some epic buildings, many years. Susan, are there any provisions that, there's nothing in this that says that you can't go over to the next year, is there?
Well, I mean, depending on the reason for exceeding the contract time, you know, there might be other ramifications as well. But I agree with Marika. You really need to look, I think, at sort of the complexity of the project and be realistic about the time frame that you set in the agreement. I mean, right now with the pandemic and all the shortages of materials and all, I'm sure that's been an issue of having to make sure you build in enough time to be able to get materials. And then that's another area of managing the owner expectations for how long it's going to take. So I think you need to, you know, just be very realistic and be able to explain to the homeowner what, you know, the time frame is that you're setting.
All right, thank you very much. So with that, we've come to the end of the hour. Thank you very much, everyone, for attending. And again, thanks to Susan and Marika for bringing us through the content today very well. Thank you, Susan. Thank you, Marika.
Thank you.